This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. The issue of child and spousal support in divorce cases received national attention after the highly publicized arrest and incarceration of America's #1 deadbeat dad. Today we'll look at the current trends in courts on the issue of support and what can be done to improve the implementation of the court's orders. Our guests are the Honorable Louis Friedman, Justice of the Supreme Court in New York County. Also, Steve Gassman, a noted matrimonial specialist. Hello, Judge Friedman.
Hi, nice to be here today.
Nice to be here.
Judge, under what circumstances does a spouse, a husband who's not paying, actually get arrested and go to jail?
Well, it takes a long time under our system, unfortunately. You have to go through many steps till you get to that stage of enforcement. First, you try a judgment, and you try to attach assets, and then you try to get money from income sources such as salary or someplace else. And when all of that fails, then we start the contempt process, and you have to show a willful failure to pay. And if there's a willful failure to pay, then eventually they wind up in jail.
Yeah, but in the case of Jeff Nichols, at least publicly, he said, look, I have no money. My second wife spent all the money. I'm basically bankrupt. What do you want me to do?
I think there was a serious doubt as to whether, in fact, he had no money or access to money. He was living as I have heard the story, he was living very well, even though he claimed not to have any money. So part of the process is to establish that the deadbeat, and in Manhattan we have some deadbeat wives and moms too, that to establish that the deadbeat actually has some money. That's a very hard thing to do.
So for him to say, look, I spent it on my second wife, doesn't hold water.
No, it doesn't.
Yeah, you can't do that, Alan. You know, a lot of people have tried that, but you can't take on a new family and new obligations and say, they're the priority now, I'm not going to worry about my first family, to whom I have a legal obligation. You can't do that, and the law recognizes you can't do it.
Judge, what bothered me about that Nichols case is there he adopted 2 new children. He wasn't supporting his 3 that he had with a prior marriage, but some court allowed him to adopt 2 more children.
That's just a criticism of the kinds of investigations that are done prior to adoptions. If someone had done a proper background check, they would have realized that here's somebody who's not supporting his other children, so why would we put him in a position where he's going to have an obligation to support yet another child? But that's a different part of the process. That's not the enforcement of the support. That's a failure of the adoption system. And that, of course, is a far more complicated process.
Steve, a wife comes to you and says, listen, my husband is sleeping with his secretary. He's no longer interested in me and has told me so in so many words. I'm not working. I've raised 3 children. They're now in their teens, but I'm still home. What can I expect? How do you tell her? What do you tell her? And I have no money, by the way. I have no money in the bank of my own.
This is not an unfamiliar scenario that you pose, Alan, and there's good news for someone in that position, because there is a decided trend in the law. It's really developed over the course of the last 4 or 5 years. To a person like that, in your scenario, the wife, the chances of her getting a substantial maintenance award, and for a long duration, if not permanently, meaning until death or remarriage, are much greater than they were when equitable distribution first came to New York in 1980. And judges and lawyers, by the way, thought, oh, gee, wives should get 2-3 years maintenance and then be rehabilitated. And then people realized that, you know, let's stop and think about this. A woman in a 20-year marriage or 25-year marriage, the most productive economic years are behind her, not ahead of her. And that's just an economic fact. And courts and the law came to realize this over a period of time. And we're seeing many more decisions, Judge, I think you'll agree, where they're giving permanent maintenance.
Well, yes, Judge.
There's no question that I think certainly in the last year or thereabouts, the Court of Appeals has made it very clear that lifetime maintenance, that is until death or remarriage, is something that may occur in many more cases than everybody thought was appropriate prior to that. Now, of course, there are some differences throughout the state in terms of how those cases are implemented. So my understanding is you're more likely to find a spouse getting lifetime maintenance in New York County than you are, say, in Suffolk County.
Judge, can you give us some examples? If a husband is earning $100,000 a year, and there's 3 children and they're teenagers, I mean, if a wife is watching out there and she wants to know, well, what can she expect? You use the term maintenance. I remember it used to be called alimony.
Right.
What can she expect? What can she expect for the children? What can she expect for, because she's concerned now, she's apprehensive, she has anxiety. What are we talking about?
You can answer the question to some extent for the children, because there's a statute that tells us that depending on the number of children, there is a percentage of the earning spouse's income which is allocated for child support. One child, 17%. And that's easy.
17% of what?
That's something that has become less than clear. The statute talks about 17% of the first $80,000 of income. Above the first $80,000 of income, there have been some cases that have said you need special circumstances to get that 17% above that. The Court of Appeals, in a decision in the last 6 months, has told us that that $80,000 is not a cap, and that it may be the percentage may be used above the $80,000, but the judge has to state a reason for using the percentage as opposed to extraordinary factors.
That's one child.
That's one child.
The 2 children, 25%, 3, 29%, and we're talking about gross income. So in your hypothetical of $100,000, $29,000 for these 3 children is going to go for child support right off the bat if the judge goes to the full $100,000.
However, the husband says, listen, I gross $100,000, but let me tell you something. They take out medical, they take out pension. I only really end up with $55,000 at the end of the year.
Well, that's one of those problems which, as a judge, you say, take it to the legislature. The legislature has written a statute that makes it very clear that you apply the percentage unless there are some extraordinary reasons why you shouldn't. And assuming you're talking about $100,000, and the case in the Court of Appeals was a case involving, I think, $97,000 and $98,000, so it's safe to say that around $100,000 the application of the percentage is appropriate. If the legislature said 29% of gross income less New York City or Yonkers income tax and FICA, which is pretty close to gross income, then that's what it's going to be. And if that's unpleasant and that's unfortunate, I think that's basically the way it comes out.
So let's take that 29% or $27,000, whatever it is, and what about maintenance on top of that?
There's no answer to that. No simple answer to that.
But you have to factor that in. You have to realize that at least for the maintenance amount, he'll get a deduction from his taxes, so he won't pay
What can the wife expect as far as maintenance concerned, on general rules?
I would say in the area of $15,000 to $20,000 maximum. Under those
$15,000, $20,000 per year. Let's take.
You're talking about someone who's paying now $27,000, $28,000 in child support.
And $15,000.
This person has to live too.
So that's now we're up to almost $43,000. And let's assume he comes home with $55,000 or $60,000.
You're right. He's got to pay the federal government, the state government. There's not a lot left over.
And
Well, his take home will be a little bit greater because the maintenance is tax deductible.
Okay.
In the case you're suggesting, the maintenance would be tax deductible, so there'd be a little, the federal government would pay a portion of it.
The point I'd like to discuss, of course, is if you don't leave the spouse who's earning the money with sufficient funds to, I guess, get an apartment, he has to establish an apartment, you have to buy all the things that go into an apartment, you have to buy a newspaper, or you'd like to buy a newspaper, and if he smokes cigarettes and to and from work, and if you don't leave enough money, what happens?
Now, and even in New York County, which is known as one of the more generous counties to dependent spouses and children, it's rare when the paying spouse isn't left with enough money for his or her basic support obligation. It really doesn't happen that often.
I think the problem starts to occur in cases where the parties were living beyond their means to start with.
Okay.
And that is not an uncommon scenario where parties are actually living on credit card debt. They're borrowing money at 18% for living expenses. And now when you have a marital split up, the standard of living is going to decline. It's going to decline because they couldn't afford it before the divorce.
And they certainly can't afford it now.
Exactly. Two can't live as cheaply as one, but two together can live a lot cheaper than two separately. And now you're going to pay for two sets of rent. On $100,000 a year, you're not going to send children to private school. And that's part of the scenario that I've seen, is that people are earning $100,000 a year and they just figured out how to scrape by and send one of the children to private school, and now all of a sudden there's just not enough money for that.
Well, Judge, I assume that the court takes all these things into consideration when the judge makes the awards.
With respect to what we call the add-ons, that is private school, and when it comes to maintenance, the answer is yes. When it comes to child support, that's a factor that, although the legislation has some, if you will, cop-out provisions in it, it's pretty cut and dried. If you're talking about an income of around $80,000 and you're 3 children, you're going to pay that 29%.
What if one spouse has substantial assets from a prior marriage or an inheritance? It's not part of the marital estate, but just that's their money that they got from somewhere else.
Right.
Generally separate property, correct.
Do you take that into consideration as to the income? And
You take that into consideration in maintenance. Then there's a list of factors in the statute, and one of the factors has to do with the income and property of the parties. And so separate property doesn't exactly fit into the equation directly, but you certainly consider it.
Steve, let's talk about equitable distribution.
Sure.
You have a house, you have a cars, you may have a second home up in the Poconos or Long Island in the Hamptons or something. How does everything get divided up?
Well, what happens is first you have to look at the residences really and see if there's a need for children to continue to occupy those residences. In other words, if the children are under 18 or sometimes they use 21 and have roots in the community and should stay in that house, there's a policy of the law is for the court to keep them there with the custodial parent. So that asset either will go to one spouse in its entirety or be sold and divided at a later date. The other assets are valued and then distributed, and the trend in the law is where you have a long-term marriage, generally in that 20-year period or longer. The trend is to divide the assets on an even basis, 50-50.
Yeah, everybody points out that the New York statute is not an equal distribution statute, but equitable. That is, you have to kind of weigh all of the factors, and it's very difficult to predict at the beginning where some of these cases are going to come out. Just about every case turns on its own facts. If you have a house in the country and you have a scenario where there may not be enough money for the parties to live in terms of maintenance, chances are that the house in the country is going to get sold, and the assets are going to, and it's going to get divided with the other assets, and in a long-term marriage, probably 50-50. If you're talking about a very expensive marital residence that is perhaps more expensive than the parties can afford, it may wind up being sold even though it is a traditional home for the children, simply because nobody can afford to maintain it.
Judge, what about short-term marriages? Married 3 years, 4 years?
Now you're in a difficult area to predict.
That is a difficult area, and usually there's a short term of support that goes with that short-term marriage, and not necessarily an equal division of the assets.
Judge, talking about assets, what if one of the spouses is a professional, a doctor, a lawyer, an opera singer? How is that come into the formula?
Well, when you divide the assets, one of the assets that the party may have is a career, and the courts have told us that there is a value that can be given to that career. The party may have a license to practice, which was obtained during the marriage. Someone who went to medical school for 4 years during the marriage, whereas the other spouse provided the income to support them. They went to medical school, they went to several years of internship and residency. Obviously, that medical license is an asset, which has a value. The professional income stream, which that doctor may now have in practicing, has a separate value. And so one of the things that you have to value is the license value. Another is the income stream value as an asset. Does it make any sense in the common understanding to say that an income stream or a career has a value? The answer is no. But the laws...
We're stuck with it, aren't we?
We're stuck with it.
We're going to continue this, and you'll tell us a practical matter what actually happens right after the break. You're watching Lawline. I'm Alan Schnorman, your host. Stay with us. Hello, I'm Alan Schnorman, the host of Lawline, and I want to give you some important information about your legal rights. If you were seriously injured in an automobile, a fall down, or construction accident, you may be entitled to a substantial money award for your pain and suffering. It is important to speak to a knowledgeable attorney in that field. At my firm, Solomon & Schnorman, our practice is limited to personal injury law. We fight for the rights of accident victims. Don't try to evaluate the case yourself. If you have any questions about your accident, call us at 1-800-LAWLINE. If you're too injured to come to our office, we will come to you. The consultation is free, and we only get paid when your case is settled or won. Remember, the insurance companies have lawyers protecting their interests, and so should you. Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're talking about child and spousal support. Our guests are Judge Louis Friedman of the Supreme Court, New York County, and Stephen Gassman, a noted matrimonial attorney. Steve, right before the break, we were talking about equitable distribution and basically professional licenses. An example, we have a doctor who basically works for a hospital. He's on payroll, and he's been working there for years, and he earns a fairly good living, but just a living. He doesn't have any assets, an office or a practice or something of that nature. Are you saying that the wife, the spouse who's not the doctor, has an interest in the
It's in the future
license?
enhanced earning capacity of that individual by virtue of him having become a doctor during the course of the marriage. And if the wife contributed to that, then to the extent that he has future earnings that are enhanced because of that educational background,
Right.
that's an asset. The problem we have to wrestle with on a practical matter is all we're talking about, as the judge mentioned, is a future stream of income.
Right, and the courts have just recently told us that you have to be very careful that when you award maintenance, you don't use the same number as you've used in terms of equitable distribution. That is, you can't make it an asset and distribute it, and at the same time
Use it for income
use it to pay.
It's double dipping.
That's exactly
The
it.
same future stream is paying maintenance, is paying child support, is paying for this so-called
Steve,
asset.
what happens on a practical matter if someone has a license like that? What kind of percentage does the non-licensed
Well,
spouse
the
get?
way the courts have gotten around this, so to speak, is if there's a high valuation for this asset, so to speak, then you give a less percentage so it becomes practical and doable. No one wants to make an order where it's impossible to comply with from the get-go.
Well,
It doesn't make sense.
One of the serious problems is if you decide that the value of this practice is $1 million, and you decide to split it 50-50, that means somehow or other this person has to come up with $500,000, and there may be no cash. That is, you may be dealing with somebody who has no liquid assets at all. And
But the receipt of that $500,000 may obviate the need for that much more maintenance by the wife in that case, so you can equal it out that way.
Steve, let me ask you this. Getting back to the deadbeat dad case, the Nichols case. In that case, almost $9,000 a month was awarded to the wife, and that was done uncontested. The husband never contested it. I guess he went to Canada. When he did finally contest it, he said there's no way he could possibly pay $9,000 a month. At that time, he was making, I think he said, just a little over $100,000, $125,000. Is that what normally happens if the award is too much, the husband just doesn't pay?
Well, it's
Anything?
foolhardy if he does that, because when a court decides a contempt application, and the judge mentioned it's unruly, but there are due process rights that have to be protected because someone can be incarcerated. You have a hearing, and there has to be proof that it was willful. If there's an order, he did nothing to appeal the order, and he's just ignored it, and he's got the ability to pay, he doesn't, technically
one
he should be
of the
incarcerated.
things you look at is if someone says, I can't afford $9,000 a month, well, did they pay $2,000 a month? And I believe that
dads that pay nothing, that-
one of the problems in Nichols' case, he paid nothing. And
Well, he just felt overwhelmed, he said.
well, there's overwhelmed and there's reality. Reality is if you say you can't afford something and you pay less, it certainly shows an aspect of good faith. And so when it comes to a question of is there a willfulness, is there a an intentional failure to pay the amount that was awarded, if your answer is, I can only afford $3,000 a month, and I've been paying $3,000 a month, that tends to be listened to a lot more credibly than someone who says, it's far too much, I can't afford $9,000 a month, and I'm not going to pay anything.
Judge, is there a limit to the amount of time a husband who doesn't pay can stay in jail?
In theory, there may be one at some point, but realistically, the jail sentences for contempt are usually what we call a civil sentence. That is, it's a coercive sentence. The idea is you go to jail until you pay.
But generally, there's a 6-month limitation on that type of civil contempt.
Judge, have you found when you sentence people to jail that they usually come up with the monies that are required?
It's truly amazing. It's one of the most amazing things I've ever seen, is that as the handcuffs get clipped on, the amount of money available to pay support starts increasing. And usually several days in the Bronx House of Detention tends to loosen the pocketbook.
And some family member or some friend usually comes with the money, and usually in cash as well, Judge, very often.
Very often.
Now, Steve, I know as a matrimonial attorney, you try to settle most of your cases. What are the ingredients of a good settlement? How do you work that out?
Well, the ingredients of a good settlement are for both parties to be satisfied or equally dissatisfied. I don't know how else to put it.
When the lawyers work it out, it's the parties are equally satisfied. When the judges work it out, they're equally dissatisfied.
But there has to be that feeling, and sometimes, unfortunately, because of the emotional trauma involved in matrimonial cases, it takes one or both parties maybe a year or two to get to that point they can even think on that level. That's an unfortunate aspect of
Judge, using your experience, what percentage of cases actually get settled before you render a verdict?
Well, in the statistics in New York County are that 94% of the divorces granted in New York County are granted without anybody ever getting to see any judge. That is, they simply submit papers because they've worked out
Uncontested.
a settlement. Uncontested.
But that still means an incredible number of trials. That's what people don't realize.
That leaves at 6% of the cases, and at any one moment there are probably 1,500 or 1,600 pending contested matrimonial cases in New York County.
Now, Judge, I know you sit in New York County, and of course, I know New York County probably has some people who have the largest assets in the United States. I read something that there's a larger percentage of the Fortune 400 families right here in Manhattan than anywhere else. How do you handle one of these huge financial divorces? Is it more like a business breakup?
If they get to trial, the answer is yes, but my suspicion is that we don't get to see most of those. That when there's enough money to pay, that the parties work out a settlement, I suspect, far easier in some cases.
Sometimes those cases are much easier than the $80,000 case or $100,000 case you mentioned, where there's not enough for everybody. The cases where there is enough for everybody, sometimes they're much easier to settle.
Right, I mean, somebody who's earning, let's say, W-2 income of $1.5 million a year, and may have $20 million in assets. I suspect those cases settle far more frequently than you would anticipate. That is, these parties are not spending $1.5 million a year.
Steve, let's take us to the typical matrimonial breakup and how it gets settled. What are the ingredients? What can one spouse who is facing a potential split up of their marriage?
Well, you can anticipate a division of the marital assets, and as I said before, if it's any type of long-term marriage, you have to figure it's going to be close to a 50-50 division. You're going to be able to anticipate roughly what child support would be because of the mandatory guidelines law. Of course, in the high-income cases, whether you go above the $80,000 so-called cap remains open, but the Court of Appeals has just liberalized how judges can go higher and higher much easier. So that you can anticipate to some degree. You can anticipate that the spouse who has the assets and the income will probably pay all or part of the fees of the spouse who doesn't have the income and the assets.
I mean, the legal fees.
Exactly. And the accounting fees and the actuarial fees and maybe real estate brokers and the other professional fees involved.
Judge, let me ask you this. Many times one spouse is in their own business, and it might be a cash business, and they have 4 or 5 different retail stores and maybe 2 restaurants, and the monies that are indicated on the tax returns may not always reflect the lifestyle of the parties. How do they get around that?
My suspicion is that there are several ways of doing that as long as somebody doesn't notify the Internal Revenue Service. The reality is that the spouses get what we call discovery. That is, you get a sense of the checking accounts, a list of what expenses were paid through credit cards, and if you have a business that shows maybe $20,000 a year of net profit and the parties are spending $150,000 a year, chances are pretty good that this is going to get resolved without a trial, since neither one really wants to expose the nature of this business to the light of day.
The key is neither one really wants to, because there's joint and several liability usually, because they usually file joint returns during the good years
Joint
of the
and
marriage.
several means they're both on the hook.
Exactly.
How do you go about finding this money? Let's assume the wife says, I know he makes more money. I know it.
People have an incredible way of leaving trails, Alan. Sometimes it's by omission and sometimes it's by commission, what they do. For example, if you look at all the checks that the couple have accumulated over the course of a year, and you say, where's the check for the kids' camp, for the clothing, for this, that, and there's none, it had to be paid somehow. It was paid in cash, and there's different ways to trace the underground economy, similarly to the way the IRS does it, by the way, by a standard of living approach.
Of course, the question you raise is a little more difficult, because sometimes the spouse who's not earning the money says there's got to be more money, and in fact there isn't. That actually what has happened is
There's debt.
There's debt. And that this is the case where they've been living on the credit card debt, and the spouse who's not earning the money doesn't know it.
Judge-
And that's a terrible situation, because now you have a set of anticipations that cannot be fulfilled, and it's the kind of case that very often winds up going to trial, because the spouse that's not earning the money says, I know there has to be hidden money someplace, let's dig at it. Now the legal fees have run $50,000, $100,000, $150,000, and they can't find the assets. And I think I recall I tried one case where there had been counsel, and the wife was looking for the earnings that she knew the husband made, and frankly, she never found it. And we tried the case, the husband testified, and as I said, by this point, the wife is representing herself because she no longer can afford attorney's fees. She had paid $60,000 or $80,000 in attorney's fees before trial, never found the money. As it turns out, by coincidence, this particular gentleman was arrested by the federal government and involved in a kickback scheme, as a result of which it became apparent during the course of his testimony in criminal trials where the money disappeared to.
Judge, on a personal note, how do you like sitting in a matrimonial part? I mean, it must be, here you're deciding...
It's a timely question.
You're just deciding the cases. The jury's not deciding it. You make the verdicts.
That's one of the big problems, is that with very rare exception, there are no jury trials in matrimonial cases. You have to make decisions. On the money decisions, they're not that difficult. On the custody decisions, they're very difficult, just as our family court judges have these cases every day of the week. And
But it's a different world. You're talking about you making the tough decisions,
And with
not
that,
pointing the 6 people in a box.
Steve Gassman, thank you very much for appearing on Law Line. Justice Friedman of New York County Supreme Court, thank you for appearing on Law
welcome.
Line.
Thank you.
And as always, this is Alan Schnorman. Thank you for watching Law Line.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program is made possible by the New York law firm of Zollman and Schnorman, who specialize in the field of personal injury law, located at 63 Wall Street in New York City.